Good morning, everyone.
Hey.
Seminar today will be taken up by Dr. Nityanand Singh, who is a member of Honorable Supreme Court of India and a fellow member of Institute of Company Secretary of India. He has also secured doctorate in law. Mr. Singh is an advocate by profession and practicing at the Honorable Supreme Court of India. He has an extensive experience of more than 20 years in litigation. Mr. Singh is a partner and founder of a law firm, namely Nux and Partners. Nux and Partners has been operating as a corporate firm in retail concept and currently handling litigation matters in more than 500 districts in India. Mr. Singh is also running an NGO with the name and style Vidya Vijay Foundation and serving the poor and needy people for upliftment of their education. The name Vidya and Vijay has been derived from the name of the parents of Mr. Singh. The first word is the name of his mother, Mrs. Vidyadhari Devi, and the second word is the name of his father, Dr. Vijay Narayan Singh. Mr. Singh is a visiting faculty member of IIM, ICSI, ICAI, and many other law colleges and business schools in India. Mr. Singh has also been recognized as Bharat Ratna in the legal field. Mr. Singh is also socially and politically very much active and has contested the elections of Legislative Assembly in Delhi twice. Now, I would like to invite Dr. Nityanand Singh to continue.
Yes, thank you, Ms. Komal. Very good morning to all of you. Friends, we have today discussion concurrent remedy available to allottees under Consumer Protection Act, RERA and IBC. Then first of all, we have to understand who is the allottee. Allottee is defined under the RERA Act. So I will share and I will show what is the definition of the allottee. Allottee is defined under the RERA Act because there are the certain definitions we have to understand who is the allottee, who is the consumer, and who is the financial creditor under the IBC code. Because all are having the concurrent jurisdiction, allottee has the jurisdictions to file a complaint before RERA, consumer, as well as the NCLT under the IBC code. First of all, the allottee, the definition of allottee is very important. We will look into here allottee. Allottee in relation to the real estate project means the person to whom a plot, apartment, or building, as the case may be, has been allotted, sold, whether as freehold or leasehold, or otherwise transferred by the promoter, and includes the person who subsequently acquires the said allotment through sale, transfer, or otherwise, but does not include a person to whom such plot, apartment, or building, as the case may, is given under it. It means the persons who has directly invested in the project or purchased from the promoters, builders, the property, or purchased to transfer. Transfer means, suppose I have purchased certain property and thereafter I have transferred certain property to someone else. Then he is also came into the category of the allottees. And this act, RERA Act, came into the force on 1st May 2016. This is the date, 1st May 2016, where notification number so-and-so, except number so-and-so, dated 6th C, Gazette of India, extraordinary. Once you will understand the definition of the allottee, then you will also understand the definition of the consumer under the Consumer Protection Act. Now you will understand who is the consumer and who can file a complaint before the Consumer Commission, State Commission, or National Commission. So I am only touching upon which is very relevant to discuss all those things, because unless and until you will understand the definition of the allottee, consumer, and financial creditor, you will not able to understand where the concurrent jurisdictions, who can file a complaint. So we will also discuss about the consumer. Who is the consumer? Means unless and until the person is consumer, he cannot file a case before the Consumer Protection, before the Consumer Commission under the Consumer Protection Act. So it is also very important to understand who is the consumer. Consumer means any person who buys any goods for consideration which has been paid or promised or partly paid and partly promised or under any system of the deferred payment, and includes any user of the such goods other than the person who buys such goods for consideration, paid or promised or partly paid or partly promised or under any system of the deferred payment, when such use is made with the approval of the such persons, but doesn't include a person who obtains such goods for resale or for any commercial purpose, or hires or avails of any service for a consideration which has been paid or promised or partly paid or partly promised or under system of the deferred payment, and includes any beneficiary of the such service other than the person who hires or avails of the services for consideration paid or promised or partly paid and partly promised or under any system of the deferred payment, when such services are availed of the approval of the first mentioned persons, but does not include a person who avail of the such service for any commercial purpose. For the purpose of this clause, the expression, what do we mean by commercial purpose? It has been explained in this definition. Commercial purpose does not include use by a person of the goods bought and used by him exclusively for the purpose of earning his livelihood by means of self-employment. The expression buys and goods and hires or avails any services includes offline or online transactions through electronic means or by tele-shopping or direct selling or multi-level marketing. So we will understand who is the consumer. Consumer means the person who will purchase the goods against the consideration. Words consideration is very important, because unless and until you purchase something without consideration, that doesn't cover under the definition of the consumer. So this word consideration is very important, and whatever you are purchasing the goods or availing the services, that should not be for the commercial purpose. Commercial purpose is specifically defined. Suppose once you are purchasing 10 tracks, 12 tracks, and that is only for the commercial purpose. You are doing the business for the commercial purpose. Otherwise, if you are dealing with the properties and you are purchasing the property only for the resale purpose, then you are not a consumer. But once you are purchasing the property for your residential purpose or for your father, grandfather or mother or for your son, then you are included into the definition of the consumer. But once you are purchasing the property and the only purpose to further sell that property, then you are not a consumer. So commercial purpose is very clearly and categorically defined. Suppose if you are purchasing 2 trucks, 3 trucks, maybe 4 trucks, but only for your livelihood, and you are maybe hire 1 or 2 driver, and you are also that truck is driven by you, then this is not a commercial purpose. Then it includes in the definition of the consumer, and you are running those trucks for your own livelihood. Suppose you are taking an example, being an advocate. You are an advocate and purchasing 10 numbers of the computer and for your own livelihood, then it is not a commercial purpose, but you are running a law firm, employing more than 10-20 employees and purchasing that computer for commercial purpose, then it doesn't cover in the definition of the consumer. So you have to understand these definitions: allottee, consumer, and under the IBC, you will understand who is the financial creditor and what is the financial debt under IBC. You will go into that. What is the definition of the financial debt and who is the financial creditor. definition is provided under section 5. It starts from here, definition 5. Who is the financial creditor? Financial creditor means a person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred to. Means financial creditor means a person to whom a financial debt is owed. Suppose you are taking certain availing the loan facility from the bank, then you are, and the person who is giving the loan is the category of the financial creditor, and you are owing something. Financial debt means a debt along with interest, if any, which is disbursed against the consideration for the time value of the money included. Suppose you are availing the loan, and of course, once you are availing the loan, you have to pay along with the interest. Then the person who has given the loan is the financial creditor, and the debt is the financial debt. Money borrowed against the payment of interest, any amount raised by acceptance under any acceptance credit facility or its dematerialized equivalent, any amount raised pursuant to any note, purchase facility or the issue of the bonds, notes, debentures, loan, stock or any similar instrument, the amount of the any liability in respect of the any lease or hire purchase contract, which is deemed as a finance or capital lease under the Indian accounting standard or such accounting standards as may be prescribed. Receivables sold or discounted other than any receivables sold or non-recourse basis, any amount raised under any other transactions, including any forward sale or purchase agreement having commercial effect of the borrowing. Explanation: for the purpose of this subclause, any amount raised from an allottee, this is the important, under the definition of the financial debt, allottee is also covered. For the purpose of this subclause, any amount raised from an allottee under a real estate project shall be deemed to be an amount having the commercial effect of the borrowing. If any amount has been received from the allottee means person who has invested or purchases some goods from the promoter or builder. The expression allottee and real estate projects shall have the meaning respectively assigned to them in clause D and ZN of section 2 of the Real Estate Regulation and Development Act. We have already discussed with the allottee. So once you are the financial creditor and you are also in the category of the allottee, then you can file a case before the NCLT under the IBC code. And there is section 7, because once this IBC code come into the picture, then initially the allottee was not under the category of the financial creditor, but thereafter there was certain amendments and which provides an explanation that allottee is also come into the definition of the financial creditor. Then what happened? The person who is having invested, suppose if it is 5 lakhs, 6 lakhs, they start approaching to the NCLT. And thereafter, what happened? The number of the cases has been piled up before the NCLT of allottee under section 7 of the IBC code. What is section 7 of the IBC code? I will also explain. Initiation of the corporate insolvency resolution process by financial creditor. A financial creditor, either by itself or jointly with other financial creditors or any other person on behalf of the financial creditor, as may be notified by the central government, may file an application for initiating corporate insolvency resolution process against the corporate debtor before the adjudicating authority when the default has occurred. The question is, when there is a default, then the person who has invested in the project, suppose if he is invested in the 5 lakhs, 7 lakhs, 6 lakhs, and the builder neither refunding the amount nor giving the possession, then they approach to the NCLT for initiation of the corporate insolvency resolution process. Provided that, and initially any allottee means person, irrespective of the numbers or irrespective of the amount, they can approach to the NCLT. Earlier, when the IBC earlier came into the force, the amount was only 1 lakh. If there is a default of 1 lakh, then you can approach to the NCLT. Now it has been changed and the default amount is rupees 1 crore. But in the case of the allottee, there is amendment came that provided that for the financial creditor referred to in the clause A and B of the section 6A of the section 21, an application for the initiating corporate insolvency resolution process against the corporate debtors shall be filed jointly by not less than 100 or such creditors in the same class or not less than 10% of the total allottee of the such creditors in the same class, whichever is less. This is after amendment, but there was before amendment, before amending, inserting of this on 10% or 100, whichever is the less, any person, any allottee, a single allottee can also approach to the Honorable NCLT for initiation of the corporate insolvency resolution process. What happened in that particular case? That a person who has invested approximately 6 lakhs, 7 lakhs, or maybe 10 lakhs, or maybe 2 lakhs, approached to the NCLT and started pressurizing to the builder that yes, you have to either my refund of amount or your company will go into the under IRP process. Then number of the cases has been filed. Then there is a builder lobby. Then they have decided once a single person approaching, because there is a project of approximately 100 crores, maybe 200 crores, 500 crores. If it is a project of the 500 crores and most of the allottees has paid their amount and has taken the possessions, but some of the allottee, maybe suppose if there are 1,000 allottees and out of them 900 allottees they have taken the possessions, but maybe the 100 allottee has not taken the possession because it is his default that they did not pay the amount, and out of 100, one of the allottee may approach to the NCLT and entire company can be shut down only because of the one person. Then the person approach, the builders lobby approach the NCLT and said so that this is not the fair practice. Thereafter, the builder lobby approached to the Honorable Supreme Court, stating that this whatever the persons, including in the category of the allottee in the financial creditor, is not constitutionally valid. I will discuss, and also the question has been arises that where there is a specific provisions of RERA came into the force, then rather than approaching to the NCLT, all the allottees should go to the RERA and they approach to the RERA and take their relief, because in the RERA there is no such provision for the insolvency of the companies. Only the either refund or compensation or maybe the interest may be allowed. This question has been arises before the Honorable Supreme Court. There are the plenty of the petitions, writ petitions has been filed before the Honorable Supreme Court in the matter of Pioneer. In this matter, I will show the judgment. This is the very landmark judgment of the Pioneer Urban Land and Infrastructure Limited and others, petitioner versus Union of India. Then all the builders lobby approached to the Honorable Supreme Court and said so that what is the provisions, all the allottees to approach to the RERA rather than approaching to the IBC court under NCLT. What happened? What was the argument before the Honorable Supreme Court? I will tell in the brief, not go into this very much detail. And the lead was Dr. Abhishek Manu Singhvi, who is the learned senior advocate, appearing before the Honorable Supreme Court. And what is his contentions? I will show the contentions in the brief. Dr. Abhishek Manu Singhvi, learned senior counsel leading the charge on behalf of the real estate developers, has argued that the treatment of the allottees as financial creditor violates the two facets of the Article 14. One, that the amendment is discretionary in as much as it treats unequals equally and equals unequally, having no intelligence differentia, and two, that there are the 2 points. First one is that unequals treated equal and equals treated unequal, having no intelligence differentia, and two, that there is no nexus with the object sought to be achieved by the code. In fact, according to the learned senior counsel, the amendments fly in the face of the objects sought to be achieved by the code, that is to maximize value of the assets so that the shareholders of the corporate debtor do not suffer from the bad management or poor management. In the facts of the present cases, according to Dr. Singhvi, the bad eggs alone have been looked at, and entities like his client and many others before us who have completed building projects in time and are in every way compliant with the law can yet be jeopardized by Section 7 petitions filed under the code to blackmail them into the making payments which would divert funds which are otherwise to be used for the purpose of the project. According to the learned senior counsel, a perfectly good management which has several projects on its hands can be removed at the instance of the one LRT and either replaced, in which case the massive funds infused by the developers himself would be set at naught, or worse still lead to commercial death, in that if there are no resolution plans or all resolution plans are rejected either by the committee creditors or the authority under the code, a perfectly solvent company would then be wound up, or what I was discussing, which would not be in the interest of the anybody, least of all the bulk of allottees themselves who would want possession of the flats or apartment. According to him, therefore, these amendments are manifestly arbitrary, being excessive, disproportionate, irrational, without determining principles. For the same reason, under the petitioner's fundamental rights under Article 19(1)(g) of the Constitution of India is infracted, and amendments not being a reasonable restrictions in the public interest under Article 19(6)(g) would therefore have to be struck down. Equally, according to the learned senior counsel, the deeming fictions in the explanation 5(8)(f), what we have already discussed, who is the financial debt and who is the financial creditor. 5(8)(f) is the financial debt explanation of the code is inconsistent with the object sought to be achieved by the court and has been stretched to absurd limits, making it manifestly arbitrary. Also, the amendments made to Section 21 and insertion of Section 25A of the code to do away with the collegiality and commercial wisdom of the committee of the creditors and are manifestly arbitrarily on this count. He made an impassionate plea that it was surprising that these amendments were even made in view of the fact that there is a specific legislation, namely the Real Estate Regulation and Development Act 2016, herein referred to as the RERA, which deals in detail with the real estate sector and provides for adjudication of the disputes between allottees and the developer, together with a large number of the safeguards in favor of the allottee, including agreements in statutory form, which would replace the agreements entered into between the developer and the allottee. According to him, therefore, a reading of the RERA would show that all the concerns of the allottee would be addressed by this sector-specific legislation, and that the enactment of the sledgehammer to kill a Gantt would render the impugned amendments excessive, disproportionate, and violative of the Article 14 and 19(1)(g) of the Constitution of India on this scores also. So this plea before the Honorable Supreme Court, that even the one person can approach to the Honorable NCLT and the entire company has been stuck. So therefore, this was the argument before the Honorable Supreme Court. Then there are more than 100 writ petitions was filed. The another argument of the another senior counsel on behalf of the petitioner, that Sri Syam Dewan, learned senior counsel advocate on behalf of some of the real estate developers, made an plea that in one of the writ petitions in which it appears the real estate developers has infused over ₹100 crores in a particular project through funds that are obtained from the abroad. If in case of entities like this, developers who complete projects on time and who have never defaulted, a single allottee, what I was discussing, that single allottee can knock the door of the NCLT and obtain an admission order, the management of the corporate debtor would be removed and replaced by either somebody else, or if not possible, the company would be wound up. According to him, not only would this be the highly arbitrary and excessive, impacting the fundamental rights under Article 19(1)(g) and 13(a), but would also have the indirect effect of the dissuading foreigners from investing in this country. There are the certain questions, these questions have been raised before the Honorable Supreme Court. Then what happened, what the Honorable Supreme Court findings is, these all are the discussions were going on the different case law, different provisions of the law, what the RERA says, what the IBC says, what all are the provisions. It may be stated that Section 220, when the RERA came into the force, RERA came into the force on the 1st of May 2017. Section 3 to 19, which deal with the registration of the real estate projects and real estate agents, functions and duties of the promoters, rights and duties allotted, together with Section 14, which deals with recovery of interest or penalty compensation and enforcement of the order for the same. Section deals with the offences penalties. This came into the force on first day of May, brought into the force 1 year later, first day of May 2017. This was for the reason that the appropriate government, as defined in Section 2G, which means the various state governments and union territories were given a period of 1 year to establish, appoint the real estate regulatory authority, the executing officer, and appellate tribunal, consequent upon which the aforesaid sections were brought into the force 1 year later, in the hope that expectation that the appropriate government would set the aforesaid authorities within the period of 1 year from 1st May 2016. Thereafter, there is all those definitions discussed. And what is the findings of the Honorable Supreme Court after discussing all those things? We will come into the detail. Provisions of the law. Now we will discuss here. It is significant to note that there is no provision similar to that of the Section 88 of the RERA in the code, which is meant to be complete and exhaustive statement of the law insofar as it is subject matter of the concern. Also, the non-applicable clause of the RERA came into force on 1st May 2016, as opposed to the non-applicable clause of the code, which came into the force on the 1st December 2016. The RERA came into the force on 1st May 16, and code came into the force on 1st December 2016. Further, the amendment with which we are concerned has come into the force only on 6th June 2018. There was an amendment in 18. Given these circumstances, it is little difficult to accede to arguments made on behalf of the learned senior counsel for the petitioners that RERA is a special enactment which deals with the real estate development projects and must therefore be given precedence over the code. Whatever the argument that RERA should be given precedence over the code, which is only a general enactment dealing with the insolvency generally. From the introduction of the explanation to the Section 5A of the code, it is clear that Parliament was aware of RERA and applied some of its definition provisions so that they could apply when the code is to be interpreted. The fact that RERA in addition to and not in derogation of. In addition to means there is an additional remedy available with the RERA and not in derogation of the provisions of any other law for the time being in force. Also makes it clear that the remedies under RERA to allottees were intended to be additional and not exclusive remedy. This is the finding of the Honorable Supreme Court, that whatever the remedy available to the RERA is in addition to, not in derogation of. Means there is not the only remedy available and persons should go to the RERA only. If the allottee wants to approach to the NCLT, they can approach. There is no restrictions at all. Also, it is important to remember that the authorities under RERA were to be set up within 1 year from 1st May 16. Remedies before those authorities would come into the effect only and from 1st May 2017, making it clear that the provisions of the code which come into the force on 1st December 2016 would apply in addition to the RERA. It means whatever the remedy available to the NCLT, that in addition to the RERA, means person can approach to the RERA and NCLT both. This is the findings of the Honorable Supreme Court, because it is a judgment of the approximately 167-68 pages. Now it is clear, therefore, that even by a process of the harmonious constructions, RERA and the code must be held to coexist. And in the event of the clash, RERA must give a way to the code. Code will prevail. RERA therefore cannot be held to be a specific statute, which in the case of the conflict would override the general statute, that is the code. As a matter of the fact, the code and RERA operate in the completely different spheres. The code deals with a proceeding in realm in which the focus is in the rehabilitation of the corporate debtor. This is to take place by replacing the management of the corporate debtor by means of the resolution plan, which must be exceeded by 66% of the committee of the creditors. It is now put at the helm of the affairs in deciding the fate of the corporate debtor. Such resolution plan then puts the same or another management in the saddle, subject to the provisions of the code, so that the corporate debtor may be pulled out of the woods and may continue as a going concern, thus benefiting all stakeholders involved. It is only as a last resort that winding up of the corporate debtor is resorted to. This is the only last resort that when the company should wind up. Otherwise, there is a committee of the creditors and they can take the decision. Yes, the company can go continue or it may be wound up. So that there is assets may be liquidated and paid out the manner provided under Section 53 of the code. On the other hand, RERA protects the interest of the individual investor in real estate projects by requiring the promoter to strictly adhere to its provisions. The object of RERA is to see that real estate projects come into fruition within the stated period and to see that allottees of the such projects are not left in lurch and are finally able to realize their dream of a home or be paid compensation if such dream is shattered, or at least get back monies that they had advances towards the project with interest. At the same time, reluctant allottees are not to be tolerated, as they must also perform their part of the bargain, namely to pay installments as and when they become due and payable. Given the different spheres within which these two enactments operate, different, this is important, different parallel remedies are given to the allottees under RERA to see that their flat apartment is constructed and delivered to them in time, barring which compensation for the same and are refund of amounts paid together with interest at the very least comes their way. If, however, the allottee wants that the corporate debtors management itself be removed and replaced so that the corporate debtor can be rehabilitated, he may prefer a Section 7 application under the code. It is all the means, you can say the allottee is the king. Whatever the allottee they want to do, they can do. If the allottee wants this management should exist, they can do so. And if the allottee wants that this management should not be exist, then they can throw him under this provision of the Section 7 of the IBC. That another parallel remedy is available in recognized by the RERA itself in the provision to Section 17 subsection 1, by which an allottee may continue with an application already filed for the Consumer Protection Fora, he being given the choice to withdraw such complaint and file an application before the executing officer under the RERA, read with Section 88. So these all are the discussions of the Honorable Supreme Court in this matter. And finally, it was found that yes, RERA, Consumer Commission, and the code has a concurrent remedy available. The final conclusion is, it is approximately 186-page judgment by the Honorable Supreme Court and 3 bench judges. The conclusion is, this is the conclusion, the Amendment Act to the code doesn't infringe what was the argument of the petitioner that the amendment in the code infringes Article 14(19)(1)(g) read with 19(6)(300) of the Constitution of the India. Then the finding of the Honorable Supreme Court in this landmark judgment that the Amendment Act to the code doesn't infringe Articles 14(19)(1)(g) read with Article 19(6) or 300A of the Constitution of the India. Means at the Honorable Supreme Court finds that even a single allottee can approach to the NCLT. And also this was the question that only the RERA has the remedy to avail the remedy for the allottees. The Honorable Supreme Court said no. RERA as well as code as well as consumer all are having the parallel remedy available to the allottees. The RERA is to be read harmoniously with the code as amended by the Amendment Act. It is only the event of the conflict that code will prevail over the RERA. Code will prevail over the RERA if there is a conflict between the RERA and the code. Remedies that are given to allottees of the flats, apartments are therefore concurrent remedies. Concurrent means parallel remedies. Such allottees of the flats or apartments being in a position to avail of the remedies under the Consumer Protection Act, RERA, as well as triggering of the code. So this is the very clearly mentioned in this judgment that the code, RERA, and Consumer Commission, the allottee is the king and who can approach wherever he may deem fit. There is no restrictions at all. Thereafter, there was an amendment came in the definition of the financial debt, in which it was restricted that not a single allottee. Here, whatever we have discussed with the financial creditor definitions, I will again show. Section 7, there was an amendment takes place. Not as after this judgment, not a single allottee can approach to the Honorable NCLT, but there are the certain restrictions, and what is those restrictions are that there are the certain minimum criteria, number of the persons or number of the allottees. This is the provision added that is inserted by Act 1 of 2020 with effect from 28th December 2019. This amendment came into with effect from 28th December 2019. And this judgment, the pioneer judgment we have discussed, this judgment was passed in 9th August 2019. Thereafter, all the builders community approached to the government, yes, this is the being unfair being done, and we will not survive. Therefore, there are the certain amendments takes place on 28th December 2019, which says so, not a single allottee can approach to the Honorable NCLT, but there should be the minimum criteria, that is, provided that for financial creditors, according to clause A and B of the section 6A, section in application for initiating corporate resolution process against the corporate debtor shall be filed jointly by not less than 100 of the such creditors. Means at least 100 people who have invested in that project in the same class are not less than 10% of the total number of the such creditors, total number of the such allottees in the same class, whichever is the less. Whichever would be the less, minimum should be that person, they can only approach to the Honorable NCLT. So this amendment came. Thereafter, there are the another plenty of the judgments thereafter this pioneer. We will also discuss one by one. But before discussing, there are the certain provisions of the RERA we have to understand. Like RERA and consumer both. We will discuss first in the RERA. There are the certain provisions, specifically section 18, section 71, section 79, section 88, and section 89. Why it is so, I am saying, kindly see that there is a provisions under section 18 for refund. If you have invested certain amount, then you can ask for the refund of the amount if you are not satisfied with the builders or not completed the project within the time. Section 18. Section 18, return of the amount and compensation. If the promoter fails to complete or is unable to give possession of an apartment, plot, or building in accordance with the terms of the agreement for sale, or as the case may be, duly completed by the date specified therein. If the promoter fails to complete or unable to give possession of the apartment, plot, or building in accordance with the terms of the agreement for sale, as case may be duly completed, if the promoter is not completing the building within the particular time as you are entering into the agreement. Suppose if the agreement is for the 4 years, said that the possession will be handed over, and once he has not handed over the possession within 4 years, then what is the remedy available to you? Due to discontinuance of the business or developer on account of the suspension or revocation of the registration under this act or for any other reason, he shall be liable on demand to the allottee in case the allottee wishes to withdraw from the project without, this word is very, very important in this section 18, without prejudice to any other remedy available. Kindly see, here is a comma and here is also a comma. He shall be liable to demand on the allottees. He shall, the word shall word is very important. Shall means compulsory, you have to do. There is no options available. You have to do, it is mandatory. He shall be liable on demand to the allottee in case the allottee wishes to withdraw from the project without prejudice to any other remedy available. Whatever the remedy available, this is without prejudice. Another remedy he can also avail. And whatever the remedy here, he can avail the remedy, and he can also avail another remedy without prejudice to any other remedy available to return the amount received by him in respect of that apartment, plot, building, as the case may be, with interest as such rate as may be prescribed in this behalf, including compensation in a manner as provided under this act. Compensation and interest, provided that where the allottee doesn't intend to withdraw from the project, he shall be paid by the promoter interest for every month of the delay till the handing over the possession. There are two options. Either he wants to withdraw the project, he can withdraw from the project and take the refund. And if he doesn't want to withdraw the project, he wants to take the possession, then the builder has to give the possessions. Means overall, allottee is the king. Till handing over the possession, at such rate, if you want the possession, then the promoter has to hand it over the possessions, but unless and until he be handed over the possessions, he has to pay the interest of that amount invested. The promoter shall compensate the allottees in case of any loss caused to him due to defective title of the land on which the project is being developed or has been developed in a manner as provided under this act, and claim of the compensation under this subsection shall not be barred by the limitation provided under any law for the time being in force. If the promoter fails to discharge any other obligations imposed on him under this act, or the rules or regulations made therein, or in accordance with the terms and conditions of the agreement for sale, he shall be liable to pay such compensation to the allotee in the manner as provided under this act. Then we will discuss section 56, which is also a very important section. Because of that, here all my professional colleagues, CA, CS, ICWA, and advocate, probably all are joining this session. So this is very important for all my professional colleagues who can appear before the RERA. Right to legal representation. The applicant or appellant may either appear in person or authorize one or more chartered accountant. There is a specific sections in the RERA who provides the opportunity to the company secretary, chartered accountant, cost accountant, because all the advocates who can appear anywhere, there is no restrictions at all. But there are the certain restrictions for the CA, CS, or ICWA, because he can only appear before the tribunals, not entitled to appear before the courts. So there is a difference between courts and tribunals. But here in the RERA, this opportunity provided, especially like in NCLT as well, chartered accountant and company secretary and ICW can also appear. Here is one more opportunity before the RERA: chartered accountant, company secretary, cost accountant, or the legal practitioner, or any appellate officer to present his or her case before the appellate tribunal or the authority or the adjudicating officer as the case may be. And what is the definition? Means chartered accountant means he has to be all the company secretary and cost accountant. Then you will go to the very important section 71, power to adjudicate. There are the two authorities: real estate regulatory authority and adjudicating officer. There are the two bodies with the RERA. So kindly differentiate between the real estate regulatory authority and adjudicating officer. Adjudicating officer has only power to grant compensation and nothing else, and rest of the remedy available with the regulating authority. For the purpose of adjudging compensation, the word is very important. The very first word, for the purpose of adjudging compensation, the word adjudging compensation is very important. Under section 12, 14, 18, and section 19, the authority shall appoint in consultation with the appropriate government one or more judicial officer deemed necessary who has been district judge to be adjudicating officer for the holding an inquiry in the prescribed manner after giving an person concerned a reasonable opportunity of being heard. Means adjudicating authority has only to adjudge compensation, not anything else, provided that any person whose complaint in respect of the matters covered under section 12, 14, 18, and 19 is pending before the Consumer Dispute Redressal Forum, or this is also very important, because the person wrongly interprets that once you have filed a complaint before the Consumer Commission and you are approaching to the Honorable RERA, then you have to withdraw that complaint from the consumer. No, not it is a mandatory. The word is kindly see, provided that any person whose complaint in respect of the matters covered under section 12, 14, 18, and 19 is pending before the Consumer Dispute Redressal Forum or Consumer Dispute Redressal Commission or National Commission established under section 9 of the Consumer Protection Act, on or before commencement of this act, he may. The word is may, not shall. You should be very particular and specific about the legislature intentionally use the word may. He may, with the permission of the search forum commission as the case may be, withdraw the complaint pending before it and file an application before the adjudicating officer under this act. So it is not mandatory that you have to withdraw. It is your discretion. Allottee has the discretion. He may or may not withdraw. Once he wants to withdraw, he may withdraw, and wants to file a complaint before the adjudicating officer only for the compensation, because the purpose is the very limited. You can approach to the adjudicating authority only for the limited purpose of the compensation. There is no refund granted by this adjudicating authority. So you should be very clear about it. The application for adjudicating compensation, again in the subsection 2, adjudicating compensation under section 1 shall be dealt with by the adjudicating officer expeditiously as possible as, and in class 3, while holding an inquiry, adjudicating officer shall have the power to summon and enforce the evidence. This is all about the section 71. Then section 72, factors to be taken into account by the adjudicating officer. What are the factors taken into consideration while awarding compensation? And then we'll come on section 79. This is also very important. Bar of the jurisdictions. No civil court shall have jurisdiction to entertain any suit or proceedings in respect of any matter which the authority or adjudicating officer or the appellate tribunal is empowered by or under this act to determine, and injunction shall be granted by any court or other authority in respect of any actions taken or to be taken in pursuance of any power conferred by or under this act. Means the word is very specific. The word is civil court. Court and tribunal, both are the different things. So you should not confuse the court also includes tribunal. No, tribunal is something different, court is something different. And here they use the word civil court. So only the civil court, there is a bar on the jurisdiction of the civil court. Whatever the matter pertains to the RERA, the civil court has a bar. You cannot approach to the civil court. You can only approach to the RERA. But there is no bar on the Consumer Commission or NCLT. Then we will discuss about the section 18, because these all are the section is going to be interpreted in the judgments which I am going to discuss. Therefore, I'm focusing on that. This is very important to understand. Once you will understand this section, then easily understand what are the judgments have been referred. We will discuss about the section 88. What section 88 says? The application of other laws not barred. The provision of this act shall, in addition to and not in derogation of the provisions of any other law for the time being in force. Means the RERA, the authority, the RERA act is in addition to. Means whatever the remedy available to the another act, you can avail those remedies. Apart from that, you can also avail the remedies before the RERA. This is the provision of this act shall in addition to and not in derogation of the provisions of any other law for the time being in force. Act to have the overriding effect. The provision of this act shall have effect, overruling anything contained in any other law for the time being in force. These all are the provisions. Then we will discuss one of the sections of the Consumer Protection Act also, that is section 100. What it says? Consumer Protection Act, that is also the says the same thing, that is additional remedy available. Section 100 of the Consumer Protection Act 2019. Act not in derogation of any other law, the provision of this act shall be in addition to and not in derogation of the provision of any other law for the time being in force. So Consumer Protection Act is also section 100 says that is in addition to. RERA section 88 says that is also in addition to. So there are the different persons approached to the Honorable Supreme Court that yes, once the RERA came into the force, there is no remedy available to any other act. But it has been declined by the Honorable Supreme Court in the different judgments. We will discuss one by one. Imperia versus, that is also a very landmark judgment. Honorable Supreme Court, Imperia Structures Limited versus Anil Patni and others. In this judgment, the Honorable Supreme Court also clarified that the RERA and Consumer Commission has the concurrent remedy available, and the allottee is the king and who can approach. It is discretion of the allottee whether he want to approach. We will discuss the very relevant portions of this judgment, not the entire judgment. The relevant portions. The question arises. This is the question. The Honorable Supreme Court has framed the questions that Mr. Vikas Singh, learned senior counsel, advocate for the appellant, submitted inter alia. There is whatever the questions that once the RERA Act, that is the definitions, then that is the submissions of the petitioner, that once the RERA Act came into the force, all questions concerning the project, including issues relating to the construction and completion thereof, would be under the exclusive control and jurisdiction of the authorities under the RERA Act. The Commission therefore ought not to have entertained such commission. There was a question before the Honorable Supreme Court that once the RERA came into the force, all the questions relating to the RERA should go to the RERA only, and Consumer Commission, maybe State Commission, maybe District Commission, maybe National Commissions, doesn't have a jurisdiction to entertain such a complaint. Then what is the finding of the Honorable Supreme Court after discussing all the provisions of this RERA Consumer Protection Act? The relevant portions I'm only touching upon, and we will discuss only relevant portions of the this. All are the descriptions you will discuss. It is consistently all are understand what is the question before the Honorable Supreme Court. That the question was that once the RERA came into the force, all the issue related to the maybe completion of the project, maybe he is not refunded the amount, he is not completing the project, he is not delivering the project, all issue related to all these projects should go to the only to the RERA, not to the any other authority or not to the Commission. But the Honorable National Commission has passed an order, yes, you have to refund the amount, and the Honorable National Commission has a jurisdiction to entertain even after RERA came into the force. Then this was being challenged that RERA came into the force, National Commission doesn't have a jurisdiction. It is consistently been held by this court that the remedies available under the provision of the Consumer Protection Act are in additional remedies. I have also read section 100, therefore, additional remedies over and above the other remedies, including those made available under any special statute, and the availability of an alternate remedy is no bar in entertaining a complaint under the Consumer Protection Act. Thereafter, before we consider whether the provision of the RERA Act had made any change in the legal position stated in the preceding paragraph, we may note that an allottee placed in the circumstances similar to that of the complaints could have initiated following proceeding before the RERA Act. Once the RERA Act came into the picture, means it had not been being affected, there was the only remedy available to the allottee to go to the Consumer Protection Act. And only you person used to go to the Consumer Protection Act, that was the only remedy available. If it satisfied the requirements of suppose it is discussion that if the RERA doesn't come into the picture, then what was the remedy? If it is satisfied the requirement of being a consumer under the Consumer Protection Act, he could have initiated proceeding under the Consumer Protection Act in the additional to the normal civil remedies. Whatever the civil remedies available, you can also go to the civil court as well as go to the Consumer Protection Act. There is no bar, because Consumer Protection Act was an additional remedy before RERA. However, if he did not fulfill the requirements of being a consumer, he could initiate and avail normal remedy, civil remedies available. If the agreement with the developer or the builder provided for the arbitration, if there is an arbitration clause in the agreement, even though we can approach to the consumer, barring means avoiding the appointment of the arbitrator separately, because once there is an arbitration clause, it is compulsory to go anywhere else. Before going anywhere else, you have to go for the arbitration. But in the case of the consumer, once you are approaching to the Consumer Commission, then we can ignore that arbitration clause. It's not mandatory that we have to refer the arbitrator first. In cases covered under clause B, he could initiate or could call upon to invoke the remedies in the arbitration. In cases covered under clause E, means once you are the consumer, in accordance with the law laid down in the IMAR FGF land versus, this is the Honorable National Commission 3-bench judgment has been passed, IMAR FGF Limited and another versus Aftab Singh, he could still choose to proceed under the consumer, even though there is an arbitration clause in the agreement. Then even even there is a clause, ignoring those arbitration clause, you can approach to the Consumer Commissions. This is the landmark judgment. It is not mandatory that there is an arbitration clause, then you have to go to the arbitration only, not approaching to the Consumer Commission. Yes, we can approach. This is judgment of the Honorable National Commission. In terms of Section 18, which we have already discussed, in terms of the Section 18 of the RERA Act, if the promoter fails to complete or unable to give possession of the apartment duly completed by the date specified in the agreement, the promoter would be liable on demand to return the amount received by him in respect of that apartment if the allottee wishes to withdraw from the project. Such right of an allottee is specifically made without prejudice. This is the word is without prejudice to any other remedy available to him. The right so given to the allottee is unqualified, and if availed, the money deposited by the allottee has to be refunded with the interest as such rate may be prescribed. The provision of Section 18, subsection 118 contemplates a situation where the allottee doesn't intend to withdraw from the project. In that case, he is entitled and must be paid interest for every month of the delay till the handing over the possession. It is up to the allottee to proceed either under Section 18, subsection 1 or under provision of Section 18, subsection 1. The case of the Himanshu Giri came under the latter category. The RERA Act thus definitely provides a remedy to an allottee who wishes to withdraw from the project or claim return of his investment. It is therefore required to be considered whether the remedy so provided under the RERA Act to an allottee is the only and exclusive remedy to raise a grievance, and whether the provision of the RERA Act bar consideration of the grievance of an allottee by other fora. Then, on plain reading of Section 79 of the Act, an allottee described in category B, in paragraph 22, would stand barred from invoking the jurisdiction of the civil court. However, as regards the allottees who can be called consumer within the meaning of the Consumer Protection Act, two questions should arise: whether the bar is specified under section. There are the bar that you can approach, you cannot approach to the civil court. I have also discussed Section 79 of the RERA Act. Whether the bar is specified under Section 79, the RERA Act would apply to proceedings initiated under the provisions of the Consumer Protection Act, and where there is anything inconsistent in provision of the Consumer Protection with that of the RERA Act. Then, in this judgment, Malay Kumar Ganguly versus Dr. Sukumar Mukherjee, it was held by this court, the proceeding before the National Commissions are although judicial proceedings, but at the same time, it is not a civil court. It is also very specific. The Consumer Commission is not a civil court. Within the meaning of the provision of the Code of the Civil Procedure, it may have all the trappings of the civil court, but yet it cannot be called a civil court. There are the certain judgments have been referred. Then we will discuss provision Section 71, subsection 1 of the RERA Act entitles a complainant who had initiated proceeding under the Consumer Protection Act before the RERA Act came into the force to withdraw the proceeding under the Consumer Protection Act with the permission of the forum or commission and file appropriate application before the adjudicating officer under the RERA Act. The provision thus gives a right or an option. This is a right or an option to the concerned complainant, but doesn't statutorily force. There is no statutory requirement that yes, you have to withdraw. No, it is your discretion. It is discretion of the allottee whether he wants to withdraw or doesn't want to withdraw, but doesn't statutorily force him to withdraw such complaint, nor do the provision of the RERA Act create any mechanism for transfer of the such pending proceeding to authorized under the RERA Act. As against that, mandate in Section 12(4) of the Consumer Protection Act to contrary is quite significant. Again, in so far as cases where such proceeding under the Consumer Protection Act are initiated after the provision of the RERA Act came into the force, there is nothing in the RERA Act which bars such initiation. There is no bar you can approach the Consumer Commission. The absence of the bar under Section 79 of the initiation of proceeding before the RERA, which cannot be called a civil court, and express saving under Section 18 of the RERA Act make the position quite clear. Further, Section 18 itself specifies that the remedy under this said section is without prejudice to any other remedy available. Thus, parliamentary intent is clear that the choice or discretion is given to the allottee whether he wishes to initiate appropriate proceeding before the Consumer Protection Act or file an application before the RERA Act. It is discretion. Whether you want to go, you can go. We have already discussed about the urban land infrastructure where there is a concurrent remedy available to the allottees. Lastly, it may be noted that the Consumer Protection Act 2019 was enacted by the Parliament to provide for protection of the interests of the consumers and for the said purpose to establish authorities for the timely and effective administration and settlement of the consumer disputes and for matters connected therewith incidental thereto. Section 2, subsection so-and-so defines expression consumer, product sale, and several service respectively. Section 85 and 86 deal with the liability of the product service providers and product seller. Section 100 and 107 of Section 219 Act are the following effect. in that is we have already discussed, and that is in addition to. Overruling such appeal, anything else? So it is very clearly that RERA came into the force in 2016, but Consumer Protection Act in year 2019. Even after the RERA was in the force in 2019. Consumer Protection Act 2019 came into the force. It is very clearly said, Section 100 of the 2019 Act, akin to Section 3 of the Consumer Protection Act, and Section 106 says all sections taken are purported to have been taken under the Consumer Protection Act. It is significant that Section 100 is enacted with an intent to secure the remedies under 2019 Act dealing with protection of the interest of the consumers even after RERA Act was brought into the force. There is an also remedy available under Section 7. Thus, the proceeding initiated by the complainants in the present case and resultant action, including the order passed by the Commission, are fully saved. The order passed by the Commission was allowed. So this is very clear in this judgment also. There are the certain other judgments. I will take hardly 5 if our honorable member will allow me 5 minutes more. I will also discuss 2 judgments, and that is later on. This judgment also very clearly said so. The Honorable Supreme Court judgment, X-Person Developers Private Limited versus Sushma Ashok Sirur. The same question arises here before, that whether once the RERA came into the force, that RERA has exclusive remedy and we cannot approach the consumer commissions. The Honorable Supreme Court said, no, remedy is parallel remedy available in this judgment also. Having examined various decisions of this court, which considered similar clauses in the apartment buyer agreement and following the issue laid down in Pioneer, but on behalf of developer has to be rejected. We would hold that Commission is correct in its approach in holding that the clauses of the agreement is one-sided issue, one-sided, bound to accept the provision apartment, seek refund with interest. This question is no more res integra in Imperial Structure Limited versus Sunny. This court is speaking through Justice Uday Lalit examine the jurisdiction of the consumer forum vis-a-vis the specific remedies created under the RERA Act. This judgment comprehensively deals with all aspects of the parallel. Here is the word using parallel remedies available to the consumer under the Consumer Protection Act and the RERA Act. This judgment is also very clear. The parallel remedies available to the Consumer Protection Act as well as RERA Act. In prior structures also, the Consumer Protection Act, after a comparative analysis of both institutes, this court. The question is, it is therefore required to be considered whether the remedy so provided under the RERA Act to an allottee is the only and exclusive modality to raise agreements, and whether the provisions of the RERA Act bar considerations of the grievance of an allottee by other fora. On the strength of the law so declared, Section 79 of the RERA doesn't in any way bar the Commission or the forum under the provisions of the Consumer Protection entertain any complaint. We have already discussed Section 18. From the above two discussions referred to by us, it is crystal clear that the Consumer Protection Act and the RERA Act neither exclude nor contradict each other. In fact, this court has held that they are concurrent remedies operating independently and without primary. When institutes provisioning judicial remedies fall for consideration, the choice of the interpretive outset should also depend upon the constitutional duty to create effective judicial remedies in the furtherance of the access of the justice. Meaningful interpretation that effectuates access to justice is a constitutional imperative, and it is thus duty and must inform the interpretive corrections. We have already discussed Pioneer Urban Development. So in this judgment also, it is very clear that the parallel remedies available. And the last judgments we will discuss, but not the least, that the Honorable High Court of Punjab and Haryana in the matter of High Court of Punjab and Haryana, there are the several writ petitions has been filed. In this writ petitions, the Honorable Punjab and Haryana High Court has categorically mentioned that the remedy available to the allottee are the parallel remedies available. We will come on Yes. Here, a little bit. Here he will discuss. As far as the provision to section 70 subsection 1 of the Act is concerned, it is an enabling provisions. It enables a person whose complaint is pending in the consumer fora under Consumer Protection Act to opt to withdraw such complaints to go before the AO. However, this has to be read along with the section 88 of the Act, which clearly states that the provision of this Act shall be in addition to and not in derogation of the provisions of any other law for the time in force. It is therefore not mandatory for a person who has a complaint before the consumer fora to have his complaint transferred to the AO. He can pursue both the remedies. Here it is also very clear. He can pursue both the remedies simultaneously. The word is being simultaneously on the strength of the section 88 of the Act. If he, however, such persons opts to withdraw his complaint before the consumer fora to come to the AO, the scope of the relief he seeks would be limited to the compensation or interest. The only limited scope before the adjudicating authority. Therefore, I suggest personally that we should not withdraw the complaint from the Consumer Commission. But the question arises once we have filed the separate complaints before the different forum or commissions or before the RERA. Then once it is decided by the one forum or commission or NCLT or by RERA, then all the other applications will become infructuous. So you have to decide whether you want to go and from which authority you want to decide that application. So these all about that talks about the concurrent remedies available, and from all those discussions, it is very clear that the Consumer Commissions, RERA and IBC all have the parallel remedy, concurrent remedy available to the allottee. Wherever the allottee wants to go for, he can go for and opt the remedy available to him. Thank you to all of my learned friends for the patience hearing. And now please switch on your videos and we can have a discussions. We can have a question answer sessions. If any my learned friend want to ask any questions on this issue, you are most welcome. Switch on videos, my dear friends. All the learned friends, so I can see all those beautiful faces. Please switch on videos. Requested to all of you, please switch on videos so that I can see the beautiful faces who are joined our program and being benefited. Yes, is there any questions from anyone, please? The beautiful faces, see that Mr. Manoharan sir is also here. I'm very glad to see you.
Good. Very good, good question.
Yes, please, any questions from anyone?
Yes, Mr. Singh.
One by one, please.
Okay, good afternoon, Mr. Singh.
Good afternoon.
Actually, my name is Yogesh and I have met you in your office with Mr. Vijay Tanwani.
Nani, again, please come again.
I just met you with Mr. Vijay Tanwani in your office 1 year ago. So your voice is, I think, you have been muted.
Yes, yes, I do recognize. I do recognize. Yes, yes,
Yes.
of course. We have met earlier also. Yes, 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 yes. Please,
Definitely.
please, please.
So actually,
Nice to see you again.
thank you very much, and definitely it is pleasure for me to have you again on board.
Yes,
So
sir.
my question to you is there any pecuniary jurisdiction if we approach to the RERA or to the NCLT in case of allotment?
NCLT is the 1 crore
Yes,
rupees.
1 crore rupees. So
Yes, sir.
if we have the grievance less than the 1 crore rupees, so we cannot move to the NCLT.
In the question of the allottees, because once you are the financial creditor and once you are approaching a loan, there is a pecuniary jurisdiction of 1 crore rupees. In the question of the allottees, there is a minimum criteria of the financial debt, that is 10% or 100 members, whichever is the 10% of the total number of the allottee, or 100 members, whichever is the less. These have to be approached to the NCLT. Irrespective
So
of the
you
amount.
cannot. So you cannot approach to the NCLT alone.
No, not after the amendment, December 2019 amendment, whatever I have shown you, not after that.
Okay, okay. So whether there is a, so for example,
December, after 28 December 2019, you cannot approach as a single allottee. You have to be go on that particular minimum criteria. 10% of the total number of allottee or 100 number, whichever is the less.
okay, okay. It is up to the 100 number or 10% of the total allottees.
Yes, yes, yes.
Okay, okay, okay. So this is the criteria basically after
This is the criteria before the NCLT.
Correct.
Thank you. Any other
very,
question?
very informative information has been provided by you, Mr. Singh, through this conversation. So I'm really grateful to have you on board again. Thank you. Thank you.
Yes, of course, we used to have a session on the 2nd and 4th Saturday on different topics.
Okay.
And please share your email ID, and probably your number is the same, or?
No, sir. I'm just having this number since last 10 to 12 years. So I never changed my number.
Okay, okay. Then certainly I will add you in the group, and we keep all those information will go on, because we have also initiated it. That
I'll be sharing my email ID as well.
Email ID and telephone number both.
Sure,
So that because once the person who is participating in our session, certainly we have also issued a certificate of the participation.
Okay, okay.
So
Thank you.
it came, so that we will send it through email.
Sure.
Yes. Please, any other question? If anyone wants to ask any question, please come and ask if there is any doubt.
So my one more small question is also there.
Please.
So if we, for example, if we have moved to the consumer court,
Please.
regarding the allotment cases,
Please.
so we can also approach to the NCLT according to the judgments.
Yes, yes.
Because these are all the provisions which have been incorporated in addition.
Yes, sir. In addition. Yes.
Okay.
Remedy available to the Consumer Commission's RERA and NCLT. We can go simultaneously in all those forums.
In fact, I was saying, I was looking at a judgment.
Please.
I think which might have been passed by the Honorable Supreme Court, I think 6 months ago. So according to them, there was a clash between the RERA and NCLT. So in that judgment, it was clearly observed by the Supreme Court that the RERA will uphold or RERA will overrule the NCLT. I was looking at the judgment. I will share the judgment if I have some time or spare time to have.
Please. Because in this judgment, court will prevail over RERA.
Yes, because this judgment is just opposite to that judgment.
Certainly, we will look into.
Sure.
So, we will look into, and certainly, accordingly, we will do changes accordingly. What is the judgments, and certainly we will incorporate that judgments as well.
Correct.
because whatever the judgments I have shared with you, the SUSMA, that is the latest judgment of 2022,
Yeah.
7th April 2022. Ex-person developers versus Susma Ashok Surur. April 2022.
Sushma Ashok Surur.
Yes, sir. Ex-person developers private limited versus Susma Ashok Surur, SHIROOR. Civil appeal number 6044 of 2019.
ये नंबर बता दीजिएगा एक बार दोबारा।
Civil appeal number 6044
6044
of 2019.
Supreme Court.
Supreme Court, yes. It is also said so that the parallel remedies are available.
Thank you, sir. Thank you very much.
Yes, thank you. Thank you for all your for the patience hearing. Certainly, we'll get in touch again on the 4th Saturday with the different topics.
Nitya, just one moment.
Yes,
I
sir.
mean, I have a specific question.
Yes, sir.
Does this judgment mean, and a person cannot individually go to the consumer forum if the amount is more than 1 crore? No, it doesn't.
No. 1 crore is only in the respect of the NCLT.
Okay.
IBC code.
And okay. Then what is that?
Consumer pecuniary jurisdiction is something different. Consumer pecuniary jurisdiction, if the district, before the district commission, 50 lakhs, before the state commission, up to 2 crore. More than 2 crore, you can go to the national commission.
You said if it is 10% of the total allottees, or
that is only in the case of NCLT, IBC code.
That is for the NCLT.
Only in the case of the NCLT, not before the
otherwise,
consumer and RERA.
otherwise the fixer should be 1 crore, isn't it?
No. In the case of the allottee, there are the 10% of the total number of the allottee on the same class or 100, whichever is the less. And in any other case, if you are the financial creditor, then your amount should be 1 crore. Then you can approach to the NCLT.
And how does this consumer comes under operational creditors or financial creditors? What is it?
No. Financial creditor and consumer operational creditor doesn't deal with the consumers. Before the consumers,
No, NCLT. I am talking about NCLT.
Only financial creditor, because allottee only included in the category of the financial creditor. They are not into the operational creditor.
Operational. Okay.
Allottee doesn't fall into the category of the operational creditor.
Okay, perfect.
They are only in the category of the financial creditor.
Right. ठीक है.
Thank you, sir. I think so that everything has been clarified. It's my pleasure to discuss with all of you, learned friends. Certainly, I try my best to explain on the subject matter and keep in touch, because it is also the recorded, and there is also the YouTube channel Vidya Vijay Foundation, and these all the recordings are there. And certainly we'll have a meeting on the 4th Saturday as well. If any other questions, certainly we'll answer that questions. Otherwise, we will. Yes, Miss Ayushi Makkar, if you want to ask something, are you here? Miss Arushi Makkar, are you here? Thank you. Thank you, Miss Arushi. Yes, I have received your answer. Thanks to all of you. Thanks for the presence. Thanks. Namaskar.